So good afternoon, everybody. It's wonderful to have you all participating remotely. My name is Juliet Kostritsky. I'm the director of the Center for Business Law at the Case Western Reserve University School of Law. Today, we're really thrilled to have a webinar and presentation on Ohio's new Limited Liability Company Act. Our presenters today are Glenn Moracle and Luigi La Rochelle, with significant contribution from Dan Scheid, who is unable to be here today. So I want to introduce our two presenters. First, Glenn Moracle is a partner in the corporate and securities practice of the Cleveland office of Tucker Ellis, LLP. Over a career spanning more than 40 years, he's served clients in a wide range of industries, as diverse as financial services, investment management, manufacturing, retail, mining, oil and gas, and software development. He's helped clients form and operate entities ranging from single-member LLCs to hedge funds and other investment funds with complex management and income sharing provisions. He has assisted borrowers needing to form bankruptcy remote special purpose entities to satisfy lenders who sell into the securitization markets. He has served on the Corporation Law Committee of the Ohio State Bar Association since the 1980s and has a hand in shaping many of Ohio's business entity statutes. Mr. Moracle holds a BA from the Ohio State University, an MBA from Cleveland State University, and a JD from the Harvard Law School. So our other presenter today is Luigi La Rochelle, and he is a counsel in the Corporate and Securities Practice Group of the Cleveland office of Tucker Ellis, LLP. Luigi counsels businesses of all structures and sizes through various phases of the business life cycle, from initial formation, operations and restructuring, through maturity and succession planning. He provides tailor-made solutions to clients in the areas of mergers and acquisitions, capital markets, corporate governance, regulatory compliance, and general commercial transactions. Luigi was tapped to lead Tucker Ellis's Opportunity Zone initiative and currently heads its CARES Act task force. Luigi also co-leads the CMBA's Dismantling Systemic and Negotiated Racism Real Work Group. Luigi holds a BS from the University of Michigan, a JD from the University of Dayton School of Law, and an MBA from Cleveland State University. And with that, I'm going to turn it over to our presenters.
Thank you, Juliet, for that kind introduction. I want to mention that I was looking over the list of participants as people were signing on, and I saw a very familiar name, Gene Rickert. And that is of some real significance here because Gene also served for many decades on the Corporation Law Committee of the Ohio State Bar Association. And she was the principal draftsperson of our current LLC statute. So this feels a little bit to me as if I volunteered to give a basketball clinic, and while setting up, I look out into the audience and realize that LeBron James is in the audience. So welcome, Gene. Hope you're able to join in through Q&A or whatever method. But again, thank you to the Center for Business Law. If you're like me, when you hear there's a new statute or a statute has been amended, one of the first questions is, when does this really start to apply? When do I have to be ready for the changes? And in this case, it's not a very complicated answer, but it does have some wrinkles. The new Ohio LLC Act is part of amended substitute Senate Bill 276, which is more than 220 pages of enactment by the General Assembly. And that act actually goes effective on April 12th of this year. But the more important question is, when do the new provisions of law for LLCs, when do they really become applicable to our LLCs? And the answer to that one, for the time being, is January 1st of 2022. And when that magic date comes, it's kind of a big bang. All currently existing LLCs, ones formed before the new act, they all have to conform to the new law. Any new LLCs formed on or after that date need to conform to the new law, and they have the opportunity to take advantage of the new law. and it governs both domestic and foreign LLCs formed before, on, or after that date. Now, one aspect of the law is that the Secretary of State, the Ohio Secretary of State, will need to adopt forms and have some new procedures that don't exist under the current statute. And the scuttlebutt I've heard through the Ohio State Bar Association is that the Secretary of State's office has expressed some doubt about whether they will be ready by January 1st of next year to have all the forms, all the procedures, all the filing opportunities, have those ready to go. So there is discussion that I've heard just through the State Bar Association that the effective date of this statute may be delayed. I'm not sure how much it might be delayed, but January 1st may turn out not to be the magic date that it appears to be right now. Luigi, let's go to the next slide here. Yeah, now given the fact that the statute won't become applicable until January of next year, you might wonder, well, why are we focusing attention on it right now? That seems a long way off. And one answer I have to that is this is such a sweeping change of the statute that we really need to be preparing early to think about how we want to operate under the new statute. This is not amendments to an existing act. This is the complete deletion of Chapter 1705 and the adoption of Chapter 1706. The provisions do not line up head to head in some way. You can compare section by section to see how things have changed. I guess one way to think about that is there's no really useful redlining we can do to try to show how this statute has been changed. Now, the materials that are available at the website for this webinar include the provisions from the bill that they include Chapter 1706. And if you look at it, you'll see that it is redlined. Every single word in Chapter 1706 is underlined as being new. So it doesn't help flag where the changes are. So understanding the difference between the old law and the new law is going to be more challenging than under some circumstances. And this webinar is going to attempt to highlight some key aspects of the new law and differences as a result of the new law, but it is not going to be complete. It is not going to be comprehensive. There'll be some aspects of the new act that we won't touch on at all today. And on some of the aspects that we will touch on, we're not going to be able to cover every little bit of them. There might be parts there that would be important to you in your practice that we don't really try to bring out in today's conversation. So it's a high level roadmap of some areas that are going to be deserving of some further study. Now, one thing about the new act is I would say for the most part, it doesn't put in requirements that are going to mean you have to change operating agreements in order to come into compliance with the new act. For the most part, it is allowing more freedom for what you can do within your LLC. And so it presents opportunities that you could take advantage of under the new act that would not have been available under the old act. And in part, this is because the new act is an attempt to be a little more competitive with some of the other states that have allowed some of these features in the past that Ohio has not allowed. And as far as the approach to revising existing operating agreements or thinking about drafting operating agreements going forward, it's not as if these new opportunities necessarily would be ones where everyone involved would think this is a great idea, let's implement that. Many of the provisions allow you to tip the scales one way or the other, more, for example, as between management of the LLC and the members of the LLC. So if you represent the management of an LLC, the way you might approach a new opportunity might be to want to implement something that is very protective of management. If you represent investors in an LLC, you may take the opposite approach. So it's not as if there's one, I don't think there's one perspective to bring here to say, oh, here's what people would recommend you do with your operating agreement. Luigi, next slide, please. The new version, the new Act 1706, goes even further than old 1705 in the direction of allowing freedom of contract for the operating agreement. And one of the consequences there is it puts an even higher premium, I think, on the drafting of the operating agreement. There we go. Luigi, you want to pick up from there then?
I can. All right. Right. Great. Sorry for the hiccup. But as Glenn was talking about, the new act really emphasizes the freedom of contract principle. As we know from practice, LLCs are both a creature of the statute, under the Revised Act, and a creature of contract. And it's really giving deference to the terms of the operating agreement. And the new act really serves in this context as more as a default. And when we say default here, we mean fallback provisions for matters not discussed or provided in the operating agreement. Now, this new act really cleans up a lot of the way the old act used to read, where it would have a lot of caveats with regards to except as provided in the operating agreement. And it clearly states at the outset that this is basically a fallback position. Now, there are exceptions listed in section 170608 where the operating agreement cannot change and the act will control. And some examples are, for example, the elimination of certain fiduciary duties, or whether you can vary the nature of the LLC as a separate legal entity, or whether you can vary the court's power to govern a person who's been aggrieved by a failure of the company to provide a record as required under the act. So these are just a few examples of how there are exceptions listed in 1706, but this list is much shorter than it was in 1705. Again, showing that the freedom of contract is the overriding principle under the new act. So the new act allows the members to do a couple things, and it's codified two principles. Number one, it allows a person to become a member without making any contribution and without having any economic interest. If you recall, under 1705, members are required to make contributions of cash, property, or service. And it's specifically laying out here that you don't have to make any contribution to be a member. The second part of this is that you can be a member without having any economic interest. So I'm sure we are all used to seeing, a structure where members may have a voting interest and economic interest, or just an economic interest. What this is allowing is that for members or assignees to have just a voting interest and not receive an economic interest. On top of that, the new act allows for the operating agreement to give enforceable rights to someone who is not a party to this agreement. And this is beneficial, for example, if you want to give somebody, an outside third party, some sort of consent right? And an example that comes to mind is a single purpose entity. And Glenn, I know you worked a lot with those, and maybe you can elaborate on that principle.
Sure, let me jump in there, particularly in the financing of commercial real estate. It is a common occurrence that the lender wants to have a borrower that owns that particular commercial property and has no other entanglements, to use a non-legal term, and that the entity is going to be what we call bankruptcy remote, so that if the overarching business of which this property is a part, if there's a company that has investments in multiple properties, that the a bankruptcy of the mothership, let me call it, would not affect this particular borrower. This happens particularly where the loan will be sold into the securitization market. And one of the customary techniques for providing the the separateness and the bankruptcy remote aspect of the single purpose entity is to provide that there are certain actions that the entity cannot take, such as filing for bankruptcy, unless it has an independent director, a person with an independent capacity that is not one of the actual business people at the company, has to consent. And I think these provisions that allow having a member that has no economic interest, or allowing the operating agreement to provide enforceable rights to someone who's not a party to the agreement, dovetail really nicely with those circumstances where you're trying to give somebody a truly powerful management right, a real veto, and one where a violation of it would not just be a breach of contract claim, which might entitle one to damages, but one that actually goes to the corporate in finger quotes, governance of the entity, such that an action that was done that violated that provision could be set aside, as opposed to just claiming damages. So I think these provisions will really facilitate those situations. Back to you, Luigi.
Thank you, Glenn. So I mentioned above that there are exceptions with regards to eliminating certain fiduciary duties. And we believe the new act really streamlines the application of when fiduciary duties are required by members and managers of an LLC. Now, if you look at traditional case law, Ohio case law had provided that LLC members owe each other fiduciary duties similar to those of partners in a partnership. Currently, Chapter 1705 requires that the members be subject to a duty of loyalty and a duty of care. But you could specify in the operating agreement currently the activities that do not violate either one of those duties. Again, in line with the current theme of deferring to the principle of the freedom of contract, i.e. having the operating agreement control, the members can both limit or completely eliminate the fiduciary duties of members or managers, except for the implied covenant of good faith and fair dealing under the new act. Also under the new act, the members and managers may not eliminate liability for any act or omission that constitutes a bad faith violation or implied covenant of good faith in dealing. So the way it works under the new act is really sort of dependent upon whether the LLC has a manager. If the LLC has a manager, the only duties a member owes to each other and the LLC are the implied covenants of good faith and fair dealing. If there is no manager, the members owe a duty of loyalty and a duty of care as defined under the act.
Luigi, could I jump in with an observation here, which is even though we have the label fiduciary duties on this slide, historically the subject matter in the act was fiduciary duties, but what it boils to down now is the minimum required standard is compliance with the implied covenant of good faith and fair dealing, which is properly characterized as a contract concept as distinct from a fiduciary duty. I don't know whether that's going to make a big difference in how it plays out in practice, but you really can totally eliminate fiduciary duties under the new act, and the floor, the minimum requirement here is compliance with the implied covenant of good faith and fair dealing.
That's correct. And again, you can expand these duties under the operating agreement. So again, the freedom of contract principle applies here as well. So it's funny, if you look at the new act versus the old act, you can tell that the old act, even though it didn't use the phrases member managed or manager managed, contemplated that the LLC would be one or the other. Under the new act, the concept of a manager is really deployed differently, whereby a manager is really now just a category of agent of the LLC and has no special statutory governance status like it did under the old act. There are only a couple places that the term manager actually is listed within the new act, and that has to do with fiduciary duties and exculpatory sections, but not anywhere is it listed in the governance sections. So the new act really allows for an open-ended management structure, and it provides great flexibility for the operating agreement to specify how members and managers and other persons are allocated authority and responsibility over the LLC.
Luigi, if I could jump in there for just a few seconds, I guess this reminds me of a quip I have often made about LLCs as a form of entity, which is the best thing about an LLC is there's incredible flexibility in how you can structure it. The most challenging thing about an LLC is there's so much flexibility in how you can structure it that it's a very wide open field and may require, or it allows very creative drafting, but it may then also require a great amount of care in deciding how you want to structure. Back to you.
I think it's back to you, Glenn.
Okay, fair enough. Most LLCs are relatively closely held business operations, sometimes literally a family business. But if not a family business, often it will have been that the LLC was started by a handful of entrepreneurs who got together, maybe literally in the garage, and got this business started. And this business is their baby. That's certainly not always the case, but the idea is that generally speaking, those people who founded the club, so to speak, want to have a good bit of control over who can join the club. You don't want a stranger showing up someday saying, "Oh, I'm here for the member meeting. I'm ready to vote." Or short of that, you don't even want someone who shows up figuratively saying, "I want to get a check. I want a distribution check. When is the next distribution check coming?" And that person is an outsider that you never really contemplated would be part of the mix. So putting restrictions on the assignment or transfer of membership interests or membership rights can be very important. And by the way, the distinction there is membership interest as used in the Act refers to the economic interest, the right to receive distributions and the related tax consequences, as opposed to the membership rights to vote or to inspect books and records, participate in management. Now, the existing Act doesn't really go into talking about the enforceability of restrictions on transfer, and the new Act doesn't really go into it head on either. But the new Act, under this concept of the freedom of contract, makes very clear that the operating agreement binds members, and it also binds assignees. And those concepts would suggest that restrictions on transfer should be enforceable. There's another aspect of the new Act that I think also points very much in the direction that restrictions on transfer would be enforceable. And that is a provision that overrides certain provisions of the UCC, which I'll talk about a little bit more here in a minute. But the fact that the Act addresses those UCC provisions suggests that the draftsmen of the Act really expect that restrictions on transfer in the operating agreement would be enforceable. May I have the next slide, Luigi? All right, the UCC provisions I'm referring to are UCC 9-406 and 9-408 that are codified in Ohio as 309-406 and 309-408. And those provisions are often referred to as the overrides of anti-assignment clauses. And what they do is they say that even if there's a contractual restriction on the ability of someone to grant a security interest in this particular right or property, the UCC overrides that restriction and allows someone to get rights as a secured party. Now, not full and complete rights that would allow a foreclosure and attempt to be substituted as a new member in the LLC, but would at least allow someone to have a security interest and enforceable rights against the member in a way that would would be contrary to what someone might have intended with the contractual restrictions that they put into their operating agreement. Now, there's a provision in the new Ohio LLC Act that says those sections of the UCC do not apply to a membership interest in an Ohio LLC. And I have come to refer to this situation that the provision in the Ohio LLC Act is the anti-assignment clause, because the clause you put in your operating agreement is the anti-assignment clause. It says thou shalt not assign. The UCC says we're going to override that. We're going to say that anti-assignment provision is not in effect. So there's your anti-provision, assignment provision. And now we have a provision that says the sections in the UCC that say this section will not be in, this provision in your agreement will not be enforced fully, now overrides all of that. So I come out at the anti-assignment provision. Now, the fact that the Ohio LLC Act says that these provisions of the UCC will not apply to an Ohio membership interest does not necessarily answer the question as to whether or not the restrictions in your Ohio operating agreement will prevail and will prevent someone from obtaining a security interest in the membership interest. Because let me give you the hypothetical of a member of an Ohio LLC, and the member lives in New York. And the member goes to a bank in New York, borrows money there, and grants a security interest in the membership interest in the Ohio LLC in favor of the New York bank. Because the Ohio LLC Act that says these UCC provisions will not apply, it refers to the Ohio sections 1309-406 and 1309-408. On its face, it does not attempt to override or preempt another jurisdiction's law of that sort. So if the governing law of that security agreement and that arrangement between the borrower and the bank, if the governing law there is, for example, New York law, it may be up to New York UCC law as to whether or not those restrictions would be enforced. And historically, there hasn't been really well-decided case law that I'm aware of about how to answer the choice of law provisions there. So I guess the bottom line is we can't rely too heavily on the Ohio LLC Act saying that UCC provisions do not apply, because once you get into this interjurisdictional situation, you may get a different answer. Luigi, slide please. Now, it gets even trickier because LLC membership interests may be securities under Article 8, or they may not. And I should say, LLC membership interests are always securities under the Ohio Securities Act for securities regulatory purposes, and would generally be securities under federal securities laws. What we're talking about here is the treatment under the UCC for purposes of transfer restrictions and perfecting security interests and the like. And the Article 8 of the UCC provides that a membership interest in an LLC is not a security within the meaning of Article 8 unless the LLC expressly opts in to have the membership interest treated as securities. So if it has not made that election, the membership interests are general intangibles and not securities under Article 8. But if an LLC opts into Article 8 security status, then restrictions on transfer in the operating agreement about the ability to transfer those interests will be governed in part by Article 8. And for those of us who think back to the days when corporations were largely the form of legal entity, and the fact that if you had a restriction on transfer of stock, if you had a stock certificate and no one put the legend on it that said this stock certificate, the stock is subject to restrictions on transfer, and someone took that stock certificate, took it without knowledge of the restriction, and held a certificated security that was endorsed over to them properly, that purchaser would take free of those restrictions. Well, the same is true of a LLC membership interest if it is both covered by Article 8 because the company has opted into it, and if it is certificated. Luigi, slide, please. So this plays right into the difference between something that is an Article 8 security, or sorry, excuse me, is not an Article 8 security, and something that is a security, particularly a certificated security, and how one perfects in those. Because if it's not an Article 8 security, the only way to perfect in it is by filing in the location of the debtor, like much other UCC collateral. But if it's a certificated security, there are two different ways you can perfect your security interest in that. And one of those is by filing, but the other is by control. And control typically in this context would mean the delivery of a certificate with endorsement delivered over to the secured party. And perfection of a security interest by control trumps filing, regardless of which one occurred first. So let's go to the next slide here. And by the way, the material that I'm talking about right now, this is not really directly related to the new act, but the new act has nuances that go to the enforceability of restrictions on transfer. And whenever we talk about restrictions on transfer, I think it's important to be aware of these distinctions, and particularly in the context of bank borrowing, because my experience is that if an LLC membership interest is going to be part of the collateral under a bank loan, if you're dealing with New York lawyers, I don't mean to state, I mean Wall Street lawyers in a big credit facility, it's been very typical for them to insist that the LLC opt into Article 8 status, and that the interest be certificated, that those things be addressed in the operating agreement, and then there be paper certificates that are pledged to the lender or its collateral agent, and that they then go put into the vault. And the reason that they often insist on that is because taking it in that fashion would trump a filing that anybody else might make. And if they simply did it, if they simply perfected by filing, it is theoretically possible that someone could go through these steps and trump their position. Now, here in the local market, it's been my experience that if the collateral is not core to the facility, lenders may not be as pushy about trying to make this sort of arrangement, but it's something that I think we all need to be aware of in this environment. Next slide, please.
Thanks, Glenn. Glenn mentioned previously, we try to avoid the unintended consequence of having third parties come in and get assignment rights to members or assignees' interest. And one of those things that we account for in a lot of the operating agreements are creditors. And the new act does a good job in limiting what remedies a judgment creditor has against the interest of a debtor, member, or assignee of the LLC. A judgment creditor's sole and exclusive remedy is to receive a member's distribution through a charging order. So what does that mean? The judgment creditor has only the right to receive any distributions to which the debtor, that member or assignee, would have otherwise be entitled with respect to his membership or her membership interest. So the judgment creditor has no right to foreclose upon the charging order or the lien or the debtor's membership interest. The judgment creditor has no right to obtain possession of any of the LLC's assets. The judgment creditor has no right to exercise any legal or equitable remedies with respect to the debtor's membership interest or property of an LLC. They are only allowed to receive the distributions of the judgment or of the debtor that they would otherwise be entitled to receive under the company.
And Luigi, could I jump in there? I apologize for interrupting, but 1705 was amended a few years ago to say that a charging order is a sole and exclusive remedy. So that is not in and of itself the big change here, but it is treated in much more detail in the new act. And it describes the specific procedures in terms of what needs to be submitted to the court and how the clerk of courts is supposed to behave. So the subject matter here as a general matter is not new, but it's got a great deal more of attention, I would say, in the new act. Is that fair, Luigi?
That's a fair assessment. And it doesn't appear to affect the rights of a secured lender in any loan documents. And so, we will see, whether that is true upon application, but as for now, from our reading, we have surmised that it would not affect a secured lender's rights under loan documents. So another new addition under the new act is the expressed listing of penalties or allowable penalties for a member or assignee's breach. 1705 had no express remedies that an LLC could exercise for breach of its operating agreement by a member or assignee. And it's funny, the word penalty in the contract world is typically a no-no, right? It's typically unenforceable. What's significant about this edition is that the new act actually specifically states that there are penalties, allowable penalties and consequences for such a breach. And under 1706-08, you are permitted to enforce, the following consequences. You can reduce or eliminate the defaulting person's interest. You can subordinate the defaulting person's interest to others. You can force them to sell. You can force them to forfeit their interest back to the company. You can allow other members to loan on behalf of the defaulting member's commitment, and that's really applicable when you have when the operating agreement requires additional contributions upon call, right? You can also set a value of the defaulting member's interest, or you can apply any other penalty or consequence as agreed by the members in the operating agreement. Now, one of the most significant additions to the new LLC Act is the concept of a series, right? And a series is an individual or separate vehicle that is used to separate the assets or operations or members and managers. Each series can have its own assets, members, managers, purpose, and investment objectives. And it really can do a lot of things, right? And it's really about the separateness concept that the new act really pushes. It can hold and convey title to assets under each series. It can enter into contracts. It can grant liens and security interests in the assets of the series, and it can be sued or even be sued. And you see this in other jurisdictions, and Glenn mentioned this before. I think this addition to having a series in the new act is to be competitive with states like Delaware, Illinois, Iowa, Nevada, Oklahoma, Puerto Rico, Tennessee, Texas, and Utah, who all have the series concept underneath. Now, what's so attractive about the series is that the debts, liabilities, obligations, and expenses for each series are enforceable against the assets of that series only. And I should say at the outset that each series can be under its own name, right? The other advantage of the series is that it's not, those debts and liabilities and obligations are not enforceable against the assets of the LLC generally or any other series. The inverse is also true. The debts, liabilities, and obligations, expenses of the company generally are not enforceable against the assets of any series. So as you can see, there is this separate line between the series and the company in each series themselves. And where this is, very, where this advantage would be taken advantage of is, let's just take investment funds, right? So you see this a lot where you have multiple investors who may or may not want to invest into different investment opportunities. Another vehicle or another type of business that might take advantage of a series structure are commercial real estate management or holding companies, where you have a number of different real estate properties and you want to sort of separate the liabilities of each property.
Yeah, Lucci, can I comment there? Is that an appropriate place for me to step
Please
in?
jump in.
Yeah, let me jump in there because we have certainly kicked this around within our practice, and we think that the whole series idea is something that may be very beneficial for some opportunities. For example, Lucci referred to the investment fund, and you might have different portfolio styles that a particular investor wants to be invested in, and so Series A, may be a growth fund, and Series B may be a different type of investment strategy, and that's a pretty well established type of series structure. It's pretty easy to keep the assets separated at a separate securities portfolio that can be identified to the series, and that's probably an area where using series under the Ohio Act would not be a major step out from wouldn't be stepping off the ledge, so to speak. But the people in our practice who represent banks in credit facilities believe that the banks and their lawyers are going to be pretty cautious about any lending activity to a series, where they would be relying on the fact that that series will really operate to keep that that asset, their borrower, keep them properly separate in the way that they intend. And we've also talked with some of our business lawyers up in Chicago, where Illinois has had the opportunity for series for quite some time. And the feeling up there in our Chicago office has been that many times when they've looked at utilizing a series concept, they've ultimately concluded that the advantage, there really wasn't that much of a cost savings of keeping it in the one entity, and that it wasn't the structure that was worth really trying to do, and end up just forming separate LLCs. So while I think this is a very, very interesting idea, I think it's one that many of us at least, will want to go slow with before we see how this, until we see how this really plays out. I'm sorry, Lucci, back to you.
Thank you, Glenn. So to establish a series, you have to do two things. Number one, your articles of organization must contain a general statement that the LLC may have one or more series of assets. Okay, so if you're thinking of, if you're an existing company and thinking of amending your operating agreement or amending your business structure to allow for series, you would have to amend your articles of organization to provide this general statement. The second condition for establishing a series is that the operating agreement itself must specifically provide that the debts, liabilities, and obligations incurred with respect to a series shall be enforceable against the assets of that series only, and not against the assets of the company generally or any other series. So again, any existing entity would need to add that specific language in the operating agreement in order to establish a series. Now, there is a third requirement, and that's for maintaining a series, and that the series records must account for the assets that the series separately from other assets of the company or any other series. So basically, the records of the series must be maintained in a manner so that the assets of the series can be reasonably identified. And there are a couple of ways to do this, right? I mean, depending on what type of assets you have in the series, you can reasonably identify it by a specific listing, category, type, quantity, if it's the membership interest in the series, any computational formula or procedure, or any other method where the identity of the assets are objectively determined. But the key here is to keep it separate. And again, each series can have its own name. So, perhaps we start there with naming the series and then putting everything underneath that name to separate not only from every other series in the company, but from the assets of the company itself.
All right, let me address derivative claims. The existing Act 1705 does make provision for a derivative claim, derivative suit in connection with an LLC. But the new Act provides much more detail about that process and introduces some notions that were not contained in 17 or are not contained in 1705. And I am not a litigator, so I am not the best person to comment on what is important or unimportant in this context. But a few things here that I want to highlight are the statute now expressly requires that there be prior demand made on the company or the series, if a series is going to be the subject of the suit. And demand has to be made, and then the plaintiff has to wait 90 days before they can commence a proceeding, unless the allegation is that there would be irreparable harm to the company if the proceeding could not occur before the expiration of the 90 days. And one thing that can be happening during that 90-day period is for the company to be establishing a procedure by which to try to dismiss the claim. And if a majority of disinterested members of the company in good faith, after a reasonable inquiry, determine that the action is not in the best interest of the company, they can have the court dismiss the claim, and that's the end of it. One of the features of that I find interesting is that the statute gives some examples of things that would not create an interest, so the person would not be disinterested. And for example, a person who is one of the named defendants in the litigation is not considered interested. Can be a disinterested person for this purpose. And if the company doesn't put together a group of members that qualify for this and can dismiss the claim, they can petition the court for the court to assemble a committee of disinterested persons who can make this determination. Also, the new act allows the court to award attorney's fees either way, if it's determined that the lawsuit was beneficial, had a significant benefit to the company, the plaintiff can collect attorney's fees. But the other way around, if the court determines that the claim was not justified, was unreasonable to bring the claim, or that it was brought for an improper purpose, the company may be able to collect attorney's fees from the plaintiff. Luigi, slide, please. Okay, we're winding down to the end of our webinar, so we're going to talk about winding down the LLC. There are new provisions in 1706 that are parallel to those in the Ohio corporation law. One difference is that it is mandatory for a corporation to send certain notices to creditors when it dissolves. For the LLC, under the new act, it is an option. It is at the election of the company if it wants to give these notices. But if the company provides notices to known creditors and tells them, bring your claim within the next 90 days or be forever barred, if that claim is not brought within the 90 days, it is forever barred. Now, my reading of the statute is that doesn't mean a lawsuit needs to be commenced. It means the claim needs to be stated. But the advantage to the LLC is getting some certainty of knowing exactly what the claims are from all these people when it's trying to settle up as it winds down. Now that takes care of the known creditors that you can give a notice to. For everybody else out there, there's an alternative, an option available. Again, it is at the election of the company. It can publicize a notice of dissolution and winding up, and then that has a longer fuse on it. That bars claims where the actual proceeding is not brought within 2 years after the publication of the notice. So these are opportunities to give an LLC some repose. Next slide, Luigi, please. That concludes our prepared presentation. We thank you greatly for your participation and attention. We have a few minutes we tried to reserve for questions. And Juliet, should those come in through the Q&A function?
They should come in through the Q&A. And first of all, I wanted to thank Glenn and Luigi for a fantastic presentation. It was wonderful. So we already have one question coming in from Arthur Tassi. Does the new act allow for an oral OA operating agreement, similar to 17.05.01J?
The simple answer to that is yes. An operating agreement can be oral. In fact, you can have a mixture, which I think could get very confusing, but you could have a formal written operating agreement, and then if there were oral agreements in addition to that, all of those could constitute the operating agreement taken together. Now, there are some exceptions. For example, I believe that the obligation of a member to make a contribution to the company must be in writing. So there are some exceptions, I think very few, where an oral agreement would not suffice. Now, I actually view this as more of a trap than an opportunity, in the sense that for those people who have drafted up a very fancy agreement and think they've got everything taken care of, and then someone comes in and says, well, remember that conversation we had 2 years ago? You agreed to this. And the argument becomes, is that actually now an enforceable agreement? I think it's probably more of a danger than it is an advantage, well, depending, of course, on which side of that your client is on. I hope that was responsive.
I think it was.